In the previous lessons, what we did was spend some time talking about the idea of licenses, and we looked at the various different distinctions which you can make between different types of licenses, focusing on the idea of the bear license, for example, licenses which are coupled with a proprietary interest, as well as licenses which are part of a contractual arrangement. This lesson is going to start talking about the idea of proprietary estoppel, or sometimes known as estoppel licenses. And we are going to basically introduce proprietary estoppel in this lesson before spending a little bit more time unpacking the key components of proprietary estoppel in the next. These are the final lessons of topic number 7, looking at licenses and proprietary estoppel. And really, we're just going to begin by thinking about the idea of an estoppel license. It's an area of law which can be applied to both contractual licenses as well as bear licenses. Sometimes what this essentially requires is the court applying the equitable doctrine of estoppel in order to prevent a licensor from revoking a license in certain circumstances. Now, I will draw your attention back to when we looked at promissory estoppel in the case of contracts, but I'm going to just really reiterate the point here. What promissory estoppel essentially tells us is that if you have a contractual arrangement which has as part of it some kind of promise, and that the other party to your contract acts in a way that requires the existence of that promise. They act on the promise and they act in a circumstance understanding that the promise exists. Then you decide or try to revoke that promise, leading the other party into a situation and circumstance where they are worse off. What the court will do is apply the equitable doctrine of estoppel to prevent you from doing such a thing, to prevent you and to protect the rights of those who have acted on the promise that you have essentially held. Similar things happen when it comes to estoppel licenses. The revocation of a license in certain circumstances can be stopped using the equitable doctrine of estoppel. Estoppel licenses are a type of proprietary estoppel. Proprietary estoppel protects an individual who has performed acts and done certain things with the assumption and upon the reliance that they will receive an interest in the landowner's land, or even they will receive a fee simple. So you can sort of see the clear comparisons that you can make between promissory estoppel on the one hand, if we then look at the idea of the law of contracts, and proprietary estoppel on the other. The real main difference is not really the nature of the relationship or the nature of the acts that have taken place, but more so the kind of things that are involved in proprietary estoppel versus promissory estoppel. Proprietary estoppel concerns, obviously, interests in land and even in some circumstances, the acquisition of a fee simple. If the landowner in this circumstance where you have an assumption and then that assumption is then revoked, then if they renege on their statement and the individual has acted in a way which relies on the performance of that statement, then estoppel may be revoked. Or invoked, should I say. Now, just like with promissory estoppel and just like with any equitable doctrine, you also have to rely on things such as the equitable maxim that equity acts as a shield and not a sword. So essentially what this tells us is that it can only be used, estoppel can only be used as a defense. This is the exact same situation as is in the case of promissory estoppel. Lord Scott will define proprietary estoppel in the following case, the case of Coombe and Yeomans Rao Management Limited from 2008. They say that, quote, an estoppel bars the object of it from asserting some fact or facts, or sometimes something that is a mixture of fact and law that stands in the way of some right claimed by the person entitled to the benefit of estoppel. The estoppel becomes proprietary estoppel, a subspecies of promissory estoppel, if the right claimed is a proprietary right, usually a right to or over land, but in principle equally available in relation to chattels or choices in action. So essentially what this is suggesting here is that you should really understand proprietary estoppel as just a subspecies of the broader promissory estoppel. The only real difference here is not to do with the nature of the arrangement, the nature of the acts that are committed or done, like the promise being revoked, for example, but the only real thing that is different between proprietary estoppel and promissory estoppel is that in the former, the right that is being claimed is a proprietary right. It is a right over some land, or a right in some land, or to some land, whatever that may be. And so if we remember back to promissory estoppel, essentially what promissory estoppel does is it prevents a person from reneging on a promise for which the other has relied upon. And so the result here is that what we are doing here is we are preventing people from reneging on a promise for which the other person has relied upon in relation to a proprietary interest, an interest in or over a piece of land. Welcome back, everybody, to what is, I believe, the final lesson on topic number 7, the subject of licenses and proprietary estoppel. This lesson is going to cover the idea of estoppel in far more detail, talking about the ways in which we actually establish what proprietary estoppel is. Now, the previous lesson simply took an introduction to the subject of proprietary estoppel, essentially looking at what proprietary estoppel is, the relationship between proprietary estoppel on the one hand and promissory estoppel on the other, understanding that it of course exists as a sort of subsect of promissory estoppel, but only when it comes to the relationship between basically an estoppel relating to a proprietary interest, a proprietary right. But we didn't really go into that much detail as to the requirements to show and to establish proprietary estoppel, for example, one of the main and very important elements, of course, in this particular area. We'll examine the nature of proprietary estoppel, unpack the circumstances where an estoppel of a proprietary nature will be established. So, fundamentally, the requirements for proprietary estoppel are established in the case of Taylor Fashions Limited versus Liverpool Victoria Trustees Corporation Limited. This is a case from 1982, and they illustrate in this case that there are 4 main requirements that are necessary to instigate an instance of proprietary estoppel. There has to firstly be an assurance by the landowner. Secondly, there has to be a reliance on that assurance. So the assurance is made by a landowner, and the individual who is seeking to claim the estoppel, to claim a case of estoppel, has to then rely on that assurance. There then has to be a detriment that is incurred, and then finally there has to be unconscionability. Okay, so these are the 4 main requirements. What we're going to do now is just go through each of the requirements and put a little bit of meat on the bones, essentially, as to what these requirements are, how they work, and in the circumstances in which they can actually be applied and applicable more generally. So the first here is this idea of there being an assurance by the landowner. This can actually be shown and can be proved in a multitude of different ways. Often it arises out of either words which are spoken or potentially conduct which is done by the landowner. What will tend to happen here is that the courts will spend time inferring intentions from words and intentions from the conduct of the landowner themselves. A useful illustration of this can be seen in the case of Thorner versus Major from 2009. This was a case in which the claimant had been a worker on a farm, and the farm belonged to one of his relatives. So he was related to the owner of the farm and had been working on this farm for some time. He had therefore, as a result of being a member of the family of the owner of the farmer, had actually in fact worked for no pay. The defendant would make their will, under which they made it very clear that the claimant would be entitled to the entirety of his residual estate upon his death. So, the will would then subsequently be destroyed as a result of the falling out of the two parties, at which point the defendant would die intestate. So what the story here is, he's been working on a farm, he works for no pay under the assumption that there is a residual estate that he will be entitled to upon his death. When they fall out, this will is quashed, or this will is destroyed. The defendant dies intestate, which therefore means that the claimant had been working for no pay under an assumption that is then revoked. The House of Lords, upon making a determination of the entitlement of estoppel, would therefore examine the statements and the conduct that is made by the defendant. They concluded that the statements and the conduct of the defendant were, quote, clear enough to give rise to an estoppel. And you can understand why, because what we have here is we have an assurance that is made by the defendant. The defendant says, you will have my residual estate when I die, it is in my will, and that the claimant then acts on that assurance by working for no pay under the assumption that they will be assured the residual estate upon the defendant's death. When this is then detrimented, when this is then revoked by the defendant as a result of a falling out between the two, the question of the doctrine of estoppel then becomes a very prominent issue, at which point the House of Lords make it very clear that it can give rise to an estoppel on the basis of the statements made and the conduct of the defendant themselves. So that's the part relating to the assurance. Of course, the whole case here illustrates various different elements of estoppel, but the point of this case is to illustrate the idea that there is an estoppel, there is an assurance at least on the basis of the statements and the conduct of the defendant. We then have to think about reliance on the assurance. So not only does it have to be an assurance that is made, or a promise that is made, if we're thinking about promissory estoppel, but there also has to be a reliance on that assurance, or a reliance on that promise. The claimant then must show, upon acknowledgement of the assurance made by the landowner, that they rely on the assurance made, and then therefore make changes to their behaviour, and almost detriment themselves on the basis of this assurance. Okay? This is a key requirement for estoppel. If there is no link which shows a clear reliance on the assurance made by the landowner, then estoppel cannot take place. Because as a result of that, it is not the assurance that causes any kind of detriment, it would be another factor that causes the detriment instead. So it is very, very important that not only is there an assurance, but on the basis of that assurance, the claimant changes their behaviour in a way that causes them to detriment in some kind of way, if that assurance was to be revoked. And so we then get to the next stage. This stage obviously being this idea of there being a detriment of the assurance. The detriment will be the detriment suffered as the result of the landowner going back on their assurance for which there was a change of behaviour of the claimant. So if I basically make a promise as a landowner, I assure something, the claimant changes their behaviour as a result of this assurance, I then revoke my assurance, I then go back on that promise, and then therefore the claimant suffers as a result of which they go, well, I've changed my behaviour, I've done something to change how I'm acting in a way, assuming that this assurance is actually a bona fide in stone, if you will. It is a bona fide promise that I'm going to receive. If that is then detrimented, then there is, of course, a loss that is suffered by the claimant. This loss need not be financial, however, and the case of Gillett versus Holt illustrates this point. Again, this was also a case involving a farm. The claimants in this case had worked on a farm for a number of decades. In fact, they had given up their career opportunities to work on this farm. So they had detrimented themselves personally in order to ensure that they would have the ability to work on this farm. The reason why they detrimented themselves was because they were given assurances. The assurances were that they would inherit from the farm business. So essentially, their mindset was fundamentally something along the lines of, well, I am detrimenting myself by giving up a career opportunity, but it will all be worth it in the long run because I will be able to inherit business opportunities and inherit the farm business once the person who owns the farm at the moment has died or moved on. In time, however, the claimant would actually just be fired, and the farm would in fact be transferred onto another individual. So they had given up on the basis of they'd given up some career opportunities on the basis of this assurance. This assurance is then revoked. They are fired, and the farm is therefore transferred to another. The claimant then goes on to try and argue for the issuance of an estoppel, and the Court of Appeal agree. They say estoppel is valid in this circumstance because they had changed their behaviour as a result of the assurance. Their behaviour would have been giving up their career opportunities to do so, and so they had lost out when the claimant is then fired by the defendant, and then the assurance is revoked. And so the result of which is, when the assurance is reneged upon, the detriment was sufficient to establish a case of proprietary estoppel. Finally, then, we have the question of unconscionability. This requirement assures that essentially the mere disappointment of expectation cannot amount to an estoppel. So if I have an assurance, okay, let's say I'm a landowner, I make an assurance to a claimant. The claimant then changes their behavior as a result of this assurance. I then renege on that assurance. What's to stop the claimant from arguing an estoppel in any circumstance, in a circumstance where it is not, it is only just mere disappointment of expectation, for example? Well, it is the extent of the reneging upon the assurance is the final requirement. The reneging of the assurance has to be unconscionable. According to Lord Justice Walker in the case of Coombe versus Yeoman's Row Management Limited, they suggested that the conduct of the landowner must, quote, shock the conscience of the court. So it has to be just more than a simple promise or the potential of something in return. It should be something more than basic disappointment if they renege upon the promise. The promise itself, the reneging of that promise, and the behavior of the defendant has to shock the conscience of the court. It has to be unconscionable, such that estoppel must therefore, and as a result of which, be valid.